Good afternoon, guys. This is the video over the Commerce Clause for this week's session of Con Law Tutoring. Now, obviously, don't worry about logging into Socrative or anything like that. You'll see from the email that I have added the PDF document of this week's questions, and we only did the first two. I left the last one out because it's really not going to make a whole lot of sense until after you guys do the Lopez case in class. So I just wanted to start off with the Commerce Clause grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes, right? That's the text of it. Now, the most significant aspect of this clause is the power to regulate interstate commerce. The Supreme Court has interpreted the Commerce Clause broadly to allow Congress to regulate all interstate commercial activity, including the channels and instrumentalities of interstate commerce. And you guys will get into those terms with the Lopez case, so I don't want you to get too bogged down in that just now. But Congress may also regulate any intrastate commercial activity that is within the state that has a substantial economic effect on interstate commerce. Furthermore, under the aggregation principle, such an effect may be substantial due to the action of one individual or the cumulative actions of many. And we got that from the Wickburn case, right? Now, we'll go over these things during the course of this tutoring session. I just wanted to lay out some of the language beforehand. Now, due to such broad interpretation, the Commerce Clause is often the source of constitutional authority for federal regulation by Congress. And in fact, the rest of the semester, just about every statute we're going to be dealing with finds its power from the Commerce Clause. Note, however, that Congress may not use the commerce power to compel commercial activity, and that was from the Sebelius case, right, when they found that the commerce power was not the correct regulation really to go under it. More so, it was the they saw the healthcare regulation there as a tax, and Congress can do it under a tax, but they couldn't compel you to pay anything under the Commerce Clause, right? So when we're tackling all these cases for the Commerce Clause, I want you guys to think of it in a timeline, okay? And there's three main periods that we are going to talk about cases from, right? And those are the Civil War through 1937, right? Civil War era. The second period is 1937 through 1995, and the third period is from 1995 to the present day. So it's important to note that after the Civil War through 1937, the court adopted a very narrow view of Congress's power under the Commerce Clause. And we'll see that because some of the statutes that were challenged during that time period were struck down. And that doesn't mean that all of them were struck down, right? But some were. And I added this part here because during the second period, we'll see that all the statutes that were challenged under the Commerce Clause theory during the second period of 1937 and 1995 were allowed, okay? They were upheld. Don't get too confused with the struck down language on period one, because some statutes were in fact upheld, but I did just want to illustrate that some were struck down as compared to the second period where they were all upheld. Okay, and past 1995, you'd see that the court returned to its earlier pre-1937 view and would strike down a federal statute in the Lopez case. So, as you can see, they're color-coded just so you guys can kind of follow along a little bit easier. And our first series of cases from the pre-1937 era are where we get the majority of our tests for the Commerce Clause. Okay, so we have our E.C. Knight case, which gave us the direct and indirect case. The Shreveport rate case, which gave us the substantial effects test, and the Swift case, which gave us the stream of commerce test. Now, there's also some other cases in there that have that little tab that says morality case, right? And these are cases, as you saw in class, that the court upheld, even though that the purpose of the statute overall was to kind of regulate morality, right? Especially with the lottery case and the prostitution case, right? Although the statutes in question there have said to have been derived from some sort of Commerce Clause, power. Really, you could view those as Congress was just trying to regulate morality, and the court, in fact, ended up upholding those cases. So you just got to note for future reference that the court did uphold those statutes that essentially was regulating morality, and they did use some of the tests from that time to justify their findings or their holding, right? In the lottery case, for example, let's see here. So the lottery case, they used the stream of commerce test, okay? Obviously these lottery tickets were going to eventually end up in the stream of commerce, and therefore it was a valid exercise of congressional power under the Commerce Clause. Now, like we said in class, the direct-indirect test used in E.C. Knight was used to strike down that statute. And that's when they said that manufacturing was not commerce, right? Albeit in that case, 98% of what they were doing or what they were producing was 98% of sugar, right? Which is the vast majority of it. But they said it only indirectly affects commerce, which put them beyond the realm of what Congress could regulate under the Commerce Clause. Now, the Shreveport rate case, we found there the Congress can set maximum rates for railroads to regulate actions substantially affecting interstate commerce, right? Congress could in fact regulate the intrastate rates charged by an interstate carrier under the commerce power because they found a close and substantial relation to interstate traffic there. And we'll see that illustrated in one of the hypos, the hypothetical questions that I gave you that should be attached to this email. And we'll go on to the Swift case, the stream of commerce, right? We found there that Congress can regulate action that is part of the stream of commerce. Congress could regulate any activity that was part of the current or stream of interstate commerce under its commerce power, even though the activities challenged took place within a single state. The effect on commerce was direct, since the object of the conspiracy in that case was to restrain the sales of livestock arriving from other states, right? And we saw there they added the direct and indirect test kind of within that case as well. And those three tests rather, you will synthesize them after the Lopez test, and I'll show you guys how to do that in a coherent way, because a lot of these tests kind of overlap, right? The stream of commerce and substantially affecting tests, both of those really overlap with each other, right? Because you can have let's say, for instance, a product within the stream of commerce that obviously, if it's in the stream of commerce and for some reason, if it's regulated to where it can't be in it or something like that, then it could substantially affect interstate commerce, right? So remember that statutes regulating activity can either positively regulate that activity or negatively affect it, right? It can go both ways for this to substantially affect it, right? So it doesn't always have to be a negative effect. It can be a positive effect too. Now, the next line of cases, right, are the second period. And like I said before, this period in time is when the court upheld every statute that was challenged under the theory of Congress exceeding its power under the Commerce Clause. And historically, you have to look at it because this was 1937, right? Well, the beginning of it was, at least, and the United States, was going through the Great Depression. It was the New Deal era. So a lot of the regulation, that Congress was